Hi, everyone. Welcome to another episode of the Ask Amity Show. Today, we'd like to talk to you about holographic wills. So what is a California holographic will? While different ideas may come to mind when you hear the term holographic will, it simply refers to a will that has been handwritten as opposed to being typed out. The most commonly drafted situations is when an individual knows that they're nearing death and they're not surrounded by anyone else to help them type up an actual will. They just handwrite it in terms of making sure that their wishes are written down. Such wills are actually valid in California under select circumstances.
What are the criteria for a valid holographic will? Probate section 6111 of the California Probate Code requires that a holographic will meets certain criteria. So the first criteria is that the person making the will has testamentary capacity. That means they must be of sound mind when writing the will and must have understood they were writing a will. The second criteria is that they wrote the will in their own handwriting. So it needs to be in their own handwriting. If they've got bad handwriting, then the holographic will is not a good way to write down your wishes. But if they've got good handwriting and it's either in its entirety or wherever they fill in a blank form. So they can use one of those forms that you can find at an office supply store. So those are fine too and would be considered as a holographic will if you're just filling in certain blanks, as long as those blanks are in their handwriting and no one else's handwriting. Okay, so the third criteria is that they had testamentary intent. That is, they intended that the document would be their last will and testament. And the last criteria is that it needs to be signed by the will maker.
Right, and then certain details to also note is that a date is actually not required. So unlike typewritten wills, California state law doesn't require for holographic wills to be dated in order to be considered valid. By including a date on it, though, it does help judge and determine which one is more of a recent will if somehow this person had multiple wills, especially, if there are certain conflicting clauses. So I think even though dating is not required on the holographic will, it's something that is recommended. And then also there's no need for a notary public to sign on this holographic will in order to make it valid. So under California probate law, the court does not require notarization of holographic wills to deem them valid. In fact, testamentary instruments generally do not need to be notarized in California. And as a result, many notaries will refer testators to attorneys when asked to notarize a will. So generally speaking, if you're going to handwrite your will, make sure that you sign it individually as the will maker, but there's no need for that will to be notarized. And there's also no need for it to be dated, although recommended.
So can I revoke a holographic will? So yes, of course you can. So you can revoke any kind of will, including a holographic will, by creating a subsequent will that revokes the prior will in part, in whole, or by the presence of any inconsistencies in the later will. A testator can also revoke a will by burning, tearing, canceling, or destroying the will with the intent and for the purpose of revoking it. Either the testator or another person in the testator's presence and at their direction can revoke a will. A will executed in duplicate or any part of it is revoked if the testator or a person acting in their presence and at their direction burns, tears, destroys the will with the intent and the purpose of revoking it. Unless a will expressly provides otherwise, if after executing a will, the testator's marriage is dissolved or annulled, the dissolution or annulment revokes a disposition of property made by the will to the former spouse.
There are certain disadvantages of a holographic will. The main disadvantage of a holographic will is that the handwriting can be misunderstood or unclear. Just as Cindy said, if you have poor handwriting and it's difficult for the individual to read and determine what you actually wrote in your will, then that would pose trouble, right? A problem later on for the distribution if there's any ambiguity. This would lead to the will not being interpreted correctly. And obviously the advantage of a holographic will is that it could be easier if you're handwriting it. It could be cheaper to create this type of will instead of a standard typewritten will. But obviously there are some disadvantages, and we would recommend that you at least typewrite your will in order to make sure that it's very clear, easy to read, easy to determine what your actual intent was in terms of who you wanted to leave your estate to. In addition, probate courts often challenge holographic wills in California because they are often signed outside the presence of a witness. Therefore, the court must be convinced that the entire will is in the testator's handwriting and that it accurately represents the testator's last known wishes about their estate. However, if the court deems the holographic will to be invalid, they may distribute the testator's estate according to laws of intestate succession. So in other words, the testator's intended beneficiaries may not receive the property.
So do you want to learn more about the holographic will or anything about estate planning? Contact us. We'd be more than happy to discuss with you any estate planning topics or probate. We offer free consultations. Thank you for watching. Subscribe to our channel, and we'll see you in the next one.